Unmuted.
Yep, I'm recording.
All right, everybody, welcome to Chapter 5. We're going to go over the closing, possession, and more. This is basically just going to be the rest of the 1 to 4 family contract that we talked about yesterday. We're just going to finish it out. What I'm actually going to do is go through all the slides real quick, and then when we're done with the slides, we're going to go back and just fill out the entire contract together so we can kind of work through what each paragraph means a little bit more in detail and fill out one for yourself so you kind of get the feel of how it works. So today the learning objective is going to be describe the provisions of closing and possession paragraphs, so paragraphs 9 and 10 of the 1 to 4 family residential contract, and describe the proper use of the buyer's and seller's temporary lease agreements and the importance of holdover fees in paragraph 19 of those agreements. Discuss what may and may not be included in the special provisions paragraph of the 1 to 4 family residential contract, and fill out paragraph 12, the settlement and other expenses of the 1 to 4 family contract. We're also going to identify the paragraphs in the 1 to 4 family that do not need to be filled out and just describe rights of the parties, and describe how to properly fill out paragraphs 21 to 24 of the 1 to 4 family residential contract. Discuss the proper procedure for executing and communicating the acceptance of the 1 to 4 family contract, and describe the purpose of the final page of the 1 to 4 family contract. All right, so closing. Again, this supplement you don't have to worry about. The only reason that's there is the book basically takes all the contracts and puts them together in a booklet that you have to pay for. We're just going to pull them up on here to make it a little bit easier, so you don't have to worry about that. So basically, the parties are going to negotiate the closing date in paragraph 9A. If you can, I would either pull up a version of the contract or whatever, or like I said, we'll go through it at the end all the way. Basically, paragraph 9A is just going to say this, the closing date, the parties must close on or before this date. So again, the parties can negotiate that. Like I said before, basically any blank in the contract you can negotiate. So you can kind of pick a date. Usually 30 days is the usual for just a normal 1 to 4 family sale. If you know, for example, that like it's going to take longer for the lender to get the funding to fund the transaction, you might put 45 or something like that. Or if it's something that might take longer for a survey or for an appraisal or whatever, you can also put a little bit longer. If it's cash, you can do like 10 to 15 because again, you have the money, it's cash. You don't really need an appraisal, you don't need anything like that, you just need the inspection. But generally, it's 30 days. The closing date is only changed automatically when objections are made under paragraph 6D. Remember, 6D is where we put residential and rental use in that last yesterday. So 6D is going to have the objections to what you are allowed and not allowed to do on the property. And then if any other change in the closing date will require an amendment. And as we showed that on a previous class, we have an amendment page, which is basically going to be a promulgated form that just has a bunch of blanks for you to fill in. Either one of the blanks, you check the box, and then it says the date in paragraph 9 will be changed to blank. And you will just put in the new closing date, and then both parties will sign that amendment. But that is how that is the only way to change a closing date once the contract has been signed fully. Again, if it has not been accepted yet, if you have not fully signed it, you can just negotiate by crossing out and putting the new date you want to and having both parties initial next to that date. Another thing is that, like I said before, the closing date is actually on or before X date. So it's good if you are not sure to push it out a little bit further because you are able to close sooner than that date says. You just cannot close after that date. I had a transaction where we were not sure how long it would take for the appraiser to come through. So we actually put a 45-day closing, but then we told the seller that as soon as we get the funding for it, we're willing to close. We don't have to wait for that 45 days. The appraisal actually got done early, and we got everything done on like day 23, I think it was, or something like that. So we just went in shortly thereafter and closed on the transaction day, like 25 or 26, whatever it was. But we were able to close earlier than that date once both parties signed at title. Title will then fund the transaction. You have closed and funded, possession switches over. The buyer will then have possession of the house, and the seller would have let go of possession of the house. But you cannot close after that date, but you can close before that. And also, the buyer shall pay for the property with good funds. You might hear good funds on the exam. Basically, good funds just means it has to be funds that are basically like checkable, I guess, if that makes sense. So you cannot have funds that could go bad. A personal check is not good funds because the check can bounce or it can get lost or something like that. Cash is usually actually not good funds. A lot of people think it is. Cash is not good funds because you can forge it. However, a cashier's check or a money order is usually, they are considered good funds along with a wire transfer.
But cash isn't.
Cash is not. They stopped accepting cash because I think they've had too many people forge money, basically, and send it over that way. Whereas if you technically, if you forged money and then got a cashier's check with that forged money or whatever, when the title company gets the cashier's check is good. It's not them that loses the money. It's whoever accepted the fraudulent money in the first place that gave you the cashier's check. So in a weird way, they don't accept cash because of possible fraud, but money order and cashier's check, they have been proven, you've been basically proved to have those funds and have already handed over the funds to get that document. And when you hand it over, that's how the money's switched over. So that's why they accept those, but they won't actually accept cash or personal checks. Wire transfers, like I said, also good funds because if you will have to wire the money over prior to closing. You cannot go into the closing table and then wire it over there. I've done a transaction where my client wired over the money the day before, so that way title company got the money, was able to check that it was good, and then we went to close the next day and actually signed all the documents. So that also works. And the seller will convey title with a general warranty deed. Basically what this is saying is that in order for closing to happen, there has to be good funds and a good deed. So in order for the title to change hands, there needs to be a good deed that is changed, that is transferred over, and good funds that are transferred over. All right, possession. So possession is paragraph 9B of the 1 to 4 family contract. And it's basically the parties agree to possession in paragraph 9B. It may either be at closing and funding or according to a temporary lease agreement. There are two boxes you will check, either at closing and funding, or you will check a box that says according to a temporary lease agreement. Now, what this is saying is that at closing and funding, if you select that box, that it's not so much when you go into the title company to sign the papers, but it is when all the money has been transferred and everything has been basically said good to go, that is when you have changed possession of the property. If I am buying Aiden's house, Aiden cannot leave his keys at the title company, and then when I go to sign, I just pick up the keys. The house is still technically not in my name at that point. Even though we've all signed and everything's been signed and closed, funding has not occurred until the money has been transferred over. As an agent, you will get your money as an agent, either your broker will get a check, and then once he receives the check, he will split off his commission with you and write you the check for however much you're supposed to get. Or you can sign a disbursement form and send over your bank account information. Basically, that's the way I've done it most of the time, which is at closing, before closing, when you receive your closing disclosure, you will send over a disbursement form that basically says, this is how much the property was sold for, this is my split of the commission, this is my broker's split of the commission. Both you and your broker will sign it. You send that over along with either a voided check, or I've even used the screenshot of my bank account, like from my mobile app, that has my account number and routing info, along with my account's name. And so basically you'll send that over, and then instead of them sending my broker a check, and then my broker cutting a check with me, they will just wire me my portion of the funds immediately and send the check of the rest of the funds to my broker. If you do it that way, you will receive your funds the exact second that the buyer or the seller receives their funds. So if you are wondering, if you're a buying agent and your buyer is wondering when they technically get possession of the property, they will receive possession when you get your money, basically. Because when you get your money, that shows that the seller has also gotten their money, and therefore funding has occurred and possession has switched over. What we usually do a lot of the times for this is, the problem is that funding could take a couple of days. If you go in and close at 2 p.m. on a Friday, there's a good chance that they will not have time to actually fund the transaction on that day. And then Saturday and Sunday, they're not there, so they will not be able to fund until Monday. So you could, if you close on Friday, your buyer may not actually get possession of that property until the next Monday, or if that's a holiday, Tuesday. So that is something to be key of. I know for me at least, I always try to put my closings on like a Wednesday, just to make sure that even if something goes wrong, you get 2 days to kind of figure it out before the weekend. So that way, if you go in at 4 p.m. on a Wednesday, it'll most likely be funded Thursday morning. That way, you're not kind of stuck waiting those 3 or 4 days trying to figure out when your buyer's gonna get possession of the property. I know Justin has had a situation that's actually happened to him, where him and an agent at the time went to a closing. They sat down, their buyer signed all the contracts over. Yes, their buyer signed all the paperwork at closing. Then they were going out of town for the weekend, so they went out of town. When they went out of town, they got told, because it was Labor Day weekend, they got told after they left, they went in at like 8 a.m. to do closing. They asked when it would be funded. They said probably by noon. So him and his agent went out to eat. They came back at about 1:30 or 2 to pick up their checks from the title company. And the title company said, we haven't funded yet, because it turns out that the seller did not kind of cross this T and dot this I correctly on all of their signatures matched up except for this one signature. So we can't actually, if we can get them to come back in and cross this T and dot this I, or at least it was the buyer. If we can get them to come back in and cross this T, like just make it look like all their other signatures, then we can get the loan funded and we're good to go. Well, they couldn't get that done in time because they had already left to go to San Antonio. So they were not able to get their possession of the property in time because they couldn't close on Friday. And like I said, it was Labor Day weekend, so they were not able to get it Monday. Well, the plan was for them to go out of town Friday, come back Saturday night, and then Sunday, their kid was going to have their granddaughter was going to have a birthday party at grandma's new house with a pool and a nice place or whatever. Well, they couldn't actually move in until Tuesday because they weren't able to fund the house in time. So they actually had to do a temporary lease agreement for 4 days to basically have possession of the house 4 days before it was actually funded. So they had to sign a lease and pay the seller more money to lease the house out for 3 days or whatever. You will get yelled at by your buyer if you cause something like that to happen. So make sure that, again, that's why I say I always try to do things on like a Wednesday or a Tuesday. If I check 30 days out and that 30 days out is a Friday, I will just put it as the next Monday. Just so everybody knows that that closing is going to be on Monday, and it helps everybody know that when everything's transferred over, it's going to be Monday, possibly Tuesday if people don't get there in time on Monday. But you're not waiting 3 or 4 days for that to happen. So there's also been situations. It's very key too that with keys, when people are switching possession of a house, people tend to think that you can just leave them at title, like I said, and have title just give it to the seller. That is not correct because they don't have the house yet. They do not have possession of the house. What usually happens is that as a seller's agent, if I was selling a property, I would have them leave the keys with me, and basically I would hold them at the office, and then I will say to the buyer's agent, whenever the funds have transferred and my seller has got his money, your buyer can come to the office and pick up the keys at any time. That just keeps it to where you are not handing out the keys that your seller has to somebody who doesn't own the property. I know Justin has talked about there was a time that he had a buyer's, they were selling a house. They had a buyer's agent who went out of town. So this other agent who was representing the buyer left town for the last weekend. They were closing, I think, on like a Monday or something like that. But they went out of town for the weekend. And so she asked if she could have an assistant come and basically take a look at the house, do their final walkthrough with the buyers, and kind of, just do their final walkthrough, make sure everything's still the same as it was when they looked at it the first time, and do their due diligence to check on it one last time, which is normal practice. That's what you're supposed to do. Well, we have what's called super boxes, which are basically a Bluetooth box that the keys are in the box on the house for showings. You connect your phone to it, take the keys out, and whenever you do that, if I'm selling a house and my super box is on this house, when somebody goes and connects their phone to it, I get a notification that X agent is at the house looking at the property. It just helps kind of keep liability. I don't show back up the next day, everything's gone, and I have no idea who's been here. I do know who's been in the property because I have access to the super, so I know who it was basically. They got notified that somebody was on the property, but then they never got the notification saying the showing was over. So it happened Friday. They never got notification that the showing had ended, which means somebody never put the key back in the box. So Justin had an agent go out, just drive by the house to see, because sometimes you do this forget, sometimes you don't click it in all the way or whatever. So he just drove by to make sure everything was okay. When he drove by, there was a bunch of cars at the house. None of them were the agents, none of them were the sellers. All the cars were workers. And when he got there, they were already tearing out the ceiling fan, they were already tearing down the drywall, they were repainting one of the rooms. They were basically renovating the house for them to move in at, even though it was 3 days before closing, and they technically didn't own the property yet. People are dumb. People will do that. So this client went in. Basically, what they think happened is when the agent got there Friday, they just made copies of the keys and gave the keys to the sellers, so then the sellers could allow these other people to come into the house and renovate the house ahead of time. Now, Justin tried to call the agent. The agent was, of course, out of town, like they said, so he finally got a hold of them Monday and shooted them out because all the stuff, luckily, all the stuff that they had taken out of the house and put in all this new furniture and everything, since it had not funded yet, that is technically property of the sellers. So he said, I really hope you're going through with this transaction, because if y'all back out now, or y'all decide not to do it, thanks for renovating my house, you will have to pay to have it. If you took out a wall, you have to pay to put that wall back in. Also, all the furniture that you've now moved in, all the TVs you put in, that's all my stuff now. So I'll allow y'all, if y'all move in, to keep it, but at any point, I can just come and take it, because that is technically my property now. So people are dumb. You will have agents that will try to do dumb things, but you should never give keys. That's why possession happens at closing and funding. You should never give keys to, especially clients. You will never give keys to clients who do not have full possession of a property yet. Agents are a different story because, again, they have the opportunity to go do showings, go do walkthroughs, whatever. So you might, in a situation, have to give keys to an agent. But if you were that buyer's agent, you should never give your keys to your clients. I have heard of people not in my own firm, but in my family, who technically on that last walkthrough go and start repainting because it's their new house. They don't really think about the fact that it's not their house yet. They might have gone to the closing table, but they were on the closing table on Friday. They don't get possession until Monday when all the funds transfer and funding actually happens. So never give keys to people until funding happens, because you don't want that to come back on you. And then also, it is important for both to check with their insurance agent when possession is different than closing and funding. That is very, very key. I know Justin has talked, him and his mom Linda, they actually know somebody personally who they were buying a house, they bought it, let's say they put a 30-day closing on it. That closing was supposed to be on Friday. Everybody went in and signed on Tuesday, so they actually purchased the house on Tuesday. Good for them. All the funding happened, all the closing happened on Tuesday. They get possession of this new house. What they didn't do was they did not check with their insurance person to change the date of their possession to Tuesday. Technically, their insurance would still kick in on Friday. Their insurance did not kick on Tuesday. And on Thursday, lightning struck the house and half the house burned down. Well, on Thursday, they don't have insurance for the house because their insurance kicks in on Friday when they were supposed to be funded and closed. So it's very key that if you are changing the closing date for any reason, to have both parties check with their insurance agents to correct the closing date with them so they know when possession is going to change hands. You do not want your client to close early and that be a good thing, and then when they get to the house, move in one day, some stuff blows up or whatever, or the water heater explodes upstairs and floods half the house, but their insurance doesn't kick in until 3 days later, so they have no insurance for the coverage. So, yeah, that's something you do not want to happen. All right, temporary lease forms. So there is a seller's temporary lease and a buyer's temporary lease. So the seller's temporary lease is used when the seller is staying after closing. All rent and deposits to be made at closing. That's also very key. the max you can do down here says leases cannot extend 90 days or not exceed 90 days. So temporary leases can only be 3 months long, and that's it. However, it says here all written deposits are to be made at closing. So if I am selling my house, but I don't have a new house to go to yet, let's say Aiden is buying my house. I'm looking for a house, but I haven't found one that fits me yet. But we close in 3 days. Well, I can sign a 3-month lease with him. So basically, I can stay in the house I've just sold for 3 months until I find a new house. But at closing, when closing happens and we go to the closing table, when he pays for my house, I also have to pay him for those 3 months of rent, or 2 months, or 1 month, however much we agreed on for the rent. But it all has to be made ahead of time at closing. So if I pick 3 months, I have to pay all 3 months plus the 1 month security deposit. If it's $2,000 a month, I pay him $8,000 at closing to rent my own house out that I just sold for 3 months. Yes, it can be very annoying. I know we're actually dealing, not us, but we know an agent who's dealing with a client they sold their house, but they're very picky on looking for the house they're going to buy, and so they kind of they can't pick a house to move into, so they've just been leasing out their own house for, I think at this point it's been about 2.5 months like that. However, this seller's temporary lease, it is not refundable. Not refundable. So if I pick 3 months to lease my house out, I'm selling my house to Aiden. We agree on a 3-month lease for me to move into, or for me to live there for 3 months until I find a house. If I find a house on day 2, I've already paid him the $8,000 at closing for the 3 months rent. I don't get any of that money back. He just gets to keep it, and whenever I move out, he can move in. That's just how it goes, but this is not refundable. So I know Justin says it's actually sometimes better to just get a regular lease, not just get a short-term residential lease as opposed to a temporary lease, because you actually have that proration of if you get it for 2 months and leave after 1 month, you can pass off the next month's rent and stuff like that. So sometimes it's better to do that, but these are what's normal in that situation. A buyer's temporary lease. So this is used when a buyer is moving in early. All rent and deposits are to be made at move-in. Now, this is again what I was talking about with when they did closing and funding, or they went into close and fund and they had to come back and reassign documents. Well, they couldn't. They had to do a temporary lease for a few days so they could have their granddaughter's birthday party. This also happens. You'll see these a lot more when somebody's trying to buy and sell a house at the same time. So if I'm trying to sell my house to Aiden and buy a house from Wyatt at the same time, if the sale of my transaction goes through with Wyatt, let's say my sale goes through easier or quicker, well then I have to live in that house an extra few days until my purchase goes through. So I will get a 1-month temporary seller's lease so I can live there for the month until the purchase of my new house comes through to move in. Or the other way around, if I buy a house, this would be a situation where like if you buy a property and you want to move in, but let's say your house is sold early. So if my house sells early, I can either if my house sells early, you can either choose to stay in the house that you currently are in for the extra amount of time, or you can choose to see if you can sign a lease agreement with the person you're purchasing a property from, and move into that house early before closing and funding. But in that case, again, in that box earlier on 9B, you have to select that possession changes hands according to a temporary lease agreement, not according to closing and funding. However, in these lease forms, landlords are not subject to the landlord-tenant laws. So there's actually a lot more liability on the landlords. Usually with landlord-tenant laws, it basically covers the landlords in case of something happening to the property. If I'm renting a house, like I'm actually renting a house and I, punch through a wall or whatever, the landlord is covered in that situation. It's not fully on him. It's part of my damage to the property, and I would have to pay for it. They're not subject to the same laws. Not saying that in that case it's still the landlord who has to pay for it, but like there are different laws that you not get covered the same way as a landlord as you would if you were actually a landlord for a renter. Instead, you're a landlord for a temporary lease for a house. I know it seems confusing. Sorry about that. It's just how it is. Special provisions. So licensees may add business details and factual statements in paragraph 11. Again, paragraph 11 is the special provisions paragraph. What this is, and like I said before, this would be something you would add, such as When we purchase the house, do you mind leaving the keys in the lockbox out front for 3 days so we have the chance to move in that way, as opposed to leaving them at the seller's agent office or whatever. You can put in little business details like that, but you cannot, care must be taken to never add anything that changes the legal rights of the parties. Parties need to seek legal advice to add things that change legal rights. What that is saying is that you cannot throw in there, if blank happens, we get our earnest money back and can leave. You cannot, that's a legal right that the seller has to, or the buyer has. You cannot change that with this paragraph 11 special provisions. So in paragraph 11, you cannot change legal rights, and you cannot add anything that is there is an addendum or an amendment for. You cannot write in paragraph 11 that I want the stove, the fridge, and the washing machine to stay behind at funding or at closing, because there is a non-realty items addendum that is specifically for non-realty items to be conveyed at closing. So in that case, you would use that addendum. You cannot just throw that into paragraph 11 and call it a day. All right, paragraph 12. Paragraph 12 defines which are buyer's costs and which are seller's costs. So yeah, so basically 12 will define what the buyer is going to pay for and what the seller has to pay for. 12b says that if an expense exceeds the amount agreed by one of the parties to the contract, the party may terminate the contract unless the other party agrees to pay the excess. What 12 has in it is basically a spot that says it's a spot for the buyer to ask for some concession money back to them at closing. So what you could do is say, I will pay $300,000 for this house at closing, but I want the seller to give me back $10,000 at closing to help me pay for any excess costs, that any expenses that might have occurred after closing. This is one of these paragraphs that as a seller's agent, you have to be really careful for. I have seen many contracts that'll say, you'll get one contract at $295 and you'll get one contract at $300,000. As a seller, your seller just wants to pick the one that says $300,000. What you don't realize is in this paragraph, there's $10,000 back to them. And in the other one, there's nothing, which means that you're actually getting $290 for a house, not $300. So the other one's actually a better deal. So it's actually very key to make sure you're paying attention to this paragraph. I've had situations where, for example, I know I was mentioning my brother's house when he bought that, and we said that when they changed the closing date on us, we actually dropped the price of the house $10,000 to kind of cover any expense we would add. That's also a viable option. What we could have done is just in this paragraph added $10,000 instead of dropping the price $10,000. There's no real difference to that. The only thing this changes is the only monetary value this will change, I should say, is how much the seller will pay commission costs. If you get a contract that says $290 and you get one that says $300,000 plus 10% or $10,000 in closing costs, your seller will have to pay commission on $300,000 because that is the sale price of the house, not $290 for both of them. So they're actually going to pay more commission on the one that's higher with expenses coming out of it. Now, I know I was doing a deal with a client of mine who was selling his house, and we got an offer come through. I think the house was for like $365, and we had an offer come through that said, "How about $360 plus $7,000 in closing and concessions?" And I was like, "Well, you're only getting $250 or $353 at that point. You're not getting $360. You're getting $360 minus $7,000. You have to pay back to them. You're getting $353." So we basically came back and said we couldn't accept that. Do you have any better offers for us? And their response was, "Well, how about $359, but only $6,000 in closing costs or in concessions?" And I was like, "That's still $350. You haven't changed anything. You went from $360 minus 7 to $359 minus 3. You're still at $353. Nothing's changed." So it's like the only thing that does is give me less money as a really nothing changes. It's like you're still getting the same amount. My sellers would have saved I think $200 on. That's it. You don't save much on that. So it's very key in this situation to double check. I guess it would save $60. It's very key to make sure that you're paying attention to this expense section of the contract. And again, when we go through the contract, I'll kind of point this out to you there. But this is just something you don't want to get caught off guard with if you're a seller's agent. You don't want to advise your clients, well, this is a way better deal when you haven't looked at this paragraph yet. So be wary of that. All right, prorations. So paragraph 13 explains that since taxes are paid in arrears, and if you look at arrears, the main word I see in there is arrear, which basically means they're paid behind, they're paid a year after. Many times tax prorations are paid on the previous year's numbers, and that if the amount turns out to be incorrect, the parties will work it out. That's my favorite sentence in here. The parties will just work it out. They'll figure it out together. No big deal. So basically, if I buy a house, let's say I buy a house this year, and for 2020, the taxes due on the property were $10,000, and I buy it halfway through the year on June 1st. If I buy it then I guess it'll be July 1st, whatever. If I buy it then, I am on the closing disclosure. It'll say that I owe, for this upcoming year, I owe $5,000 and the seller owes $5,000, because that's what last year's rates were, $10,000, and since they're prorated, we each pay half because I bought it exactly halfway through the year. Now, the problem with that is that, again, if the numbers for this year turn out to actually be different than what it was last year, the parties will just work it out. Now, Wyatt, if we go through this contract, we each pay, let's say it was $5,000 for taxes, so we each pay $250 or $2,500, right? We each pay $2,500 for taxes. Well, then a year later, or 6 months later, when taxes come due for the next year, it turns out the taxes are actually $20,000 on that property, and you only pay $2,500 for your half the year. Well, we're just going to work it out. So I'm just going to call you, and we'll just work it out. Do you want to pay the rest of that money, the other $7,500?
No.
Not really? No. No. So that's the problem with this, is the parties will just work it out. So if you'll see this a lot on land, or not land, but new homes. So if, let's say, Wyatt, you own a 10-acre piece of land, or let's say 5 acres. It's a 5-acre piece of land, and the taxes for the year before were like $75 because it's just land, nothing's there. But during that year, Wyatt built a nice 4-bedroom, 3-bath house, sold it to me for $750,000 because you built a super nice house there. It's a nice area. Well, I move in. That next year, they're going to take taxes on a 4-bed, 3-bath house that's worth $750,000, not on this random piece of land that Wyatt owned before. So do you think taxes are still going to be $75 the next year? No, it's going to be a lot more than $75. Well, again, no worries, because as a buyer, we're just going to work that out. And what I always say in that situation is that means that if I'm the seller, the buyer's going to call me, and I'm going to say no English and hang up the phone. I don't speak English, and you have the wrong phone number. I changed my phone number. I don't know. And then you're never going to hear from me again. I know Justin's actually talked about a situation where this has happened. They called the guy afterwards because he was, oh, can we call him? And they were like, you're more than willing to call the guy and work it out. So Justin's client called the guy, and he actually did change his phone number. So he could not get, there was no way to get a hold of him. So, and also, if you are a buyer's, let's say you are the seller's agent, and in that box it notices, where it says all notices will go to whoever, instead of putting, if, let's say Wyatt, I'm representing you and you're the seller, well, let's say in that box, instead of putting Wyatt's information, I put Wyatt, care of Travis Stahl, and all of my information. Well, good luck trying to contact Wyatt about all the taxes. You don't even have his information. You can't get a hold of him anymore. You can only get a hold of him through me. I'm probably not going to send you to him. And if I do, good luck him actually working it out with you. So, yeah, casualty loss. So paragraph 14 says that the seller is responsible for anything that changes during the time the property is pending, and will restore the property to its previous condition. What this is saying is that in paragraph 14, it states that if we go under contract and I'm selling my house, we go under contract with a buyer, and on day 12 or 15 or whatever, again, the water heater explodes in the attic and the floors are flooded. Well, it's actually my responsibility, and I have to pay to fix all that stuff to restore it to the condition it was in at the time of the contract being through. So I have to restore the property to its previous condition. If the house floods, it is my duty to go through and clean everything up, redo everything, remodel, probably refurnish everything to get it back to its previous condition by the time of closing. So that is something you need to be aware of as a seller. And as a buyer, be aware of that if something happens to the property, sometimes people will try to go around this, and if something happens to the property, they will say, hey, let's split the price because you're about to buy it and everything, and this just happened and whatever, how about you pay for it and I'll pay some or whatever. You are not required to as a buyer. This is requirement of the seller. So keep that in mind. Don't try to get sidetracked that way. All right, default. So paragraph 15 explains that if either party defaults under the contract, the other party has the right to enforce specific performance, sue for damages, or accept the earnest money, which releases everyone from the transaction. You will see paragraph 15 a lot, and I know we saw it a lot in other classes, and you'll see it in other paragraphs too, where it basically will say, if this was to occur, the seller has the right to paragraph 15, which is basically saying that if the buyer defaults, the seller can take all the actions, or can take actions that are recorded in paragraph 15. Now, again, like I was saying before, if your client wants to back out of a transaction and it is not the option period, or it's not a time that they are technically allowed to back out of a transaction, I will send to them my termination from my buyer or from my client, along with a release of earnest money to give them earnest money. And what I will do is I will send this to them and I will say, hey, we'd like to turn in a contract. Can you just have your seller sign this paperwork real quick, send it back to me, and we're good to go. We move on. Hopefully, they won't pay attention, or they'll just say, yeah, sure. They'll send this to their client, not really explain what's going on. Hey, sign this paperwork. You'll get to keep the earnest money. How great is that? Not realizing that by doing that, once one of the parties have accepted the earnest money, they cannot take any other action. So once you accept earnest money, you are no longer allowed to go and sue for damages. You cannot go and sue for specific performance and make the other party buy the property. This is all you can do is accept earnest money. So even though you might not want your clients to lose out on their earnest money, on their $3,000 or $2,500 or whatever, that's much cheaper than being sued to buy the property or being sued for damages or something like that. So it's much better just to have them accept the earnest money and call it a day. All right, mediation. So paragraph 16 encourages the parties to consider mediation if a dispute arises that cannot be settled by themselves. Now, the good thing for mediation is low cost, it is fast, it is private, and it is a win-win, or it's a possibility for a win-win. Now, mediation is in the same vein as arbitration. It is part of the ADR, or Alternative Dispute Resolution forms you can do. You might actually want to write down alternative dispute resolutions. That might come from the test. I feel like I remember that on my real estate exam. So just a key, you might see some questions about alternative dispute resolutions. But basically, what you are doing, if you ever heard of Judge Judy is not, she is an arbitrator. She is not she is not part of a litigation process. She is an arbitrator. Now, what mediation and arbitration does, and I know Justin actually teaches mediation courses. He actually is a mediator. But what this will do is basically, it's a lot cheaper than litigation. If somebody's getting a divorce, you can find a mediator who will charge you about $500 to maybe, I think Justin said he usually charges around $3,000 to $4,000 for the whole process to get done. Whereas if you were to do litigation, you're paying $60,000 to $70,000 in legal fees, basically, to get an attorney to come and do all this sort of stuff. Now, mediation is not legally binding, whereas arbitration is legally binding. So an arbitrator, if they make a decision on you, that is a legally binding decision that you have to follow. Same with a judge or a court. If a court says you owe this much money, that is a legally binding thing that you owe that much money, or you have to perform this duty for the other person. Mediation is more of a negotiation. It's more of just you're basically bringing in a mediator to kind of be a counselor in a way. So I know you see this a lot with divorces and marriages. They will bring in a mediator who will almost be like a marriage counselor, come in for a week, try to work it out with the parties. If the parties cannot work it out, then okay, we clearly can't get this resolved. Let me write up a judgment, basically, we can send it over to an attorney and have an attorney write out that judgment. And basically what you do at that point is you're paying the person $3,000 to $4,000 for their work, maybe $3,000 to $5,000 or so for their work for the week. And then you send it to an attorney who will just draft the paperwork up for $250. And then bam, you paid $5,200 or $3,250 or whatever you want to say. You paid that much money for a week of getting your divorce finalized, and you got some possible counseling that could have actually just helped repair your marriage. Or you can go to litigation, which will take much longer than a week. It'll take months and months and months and months. You will pay attorney fees that are through the roof, and you can get everything solved in a much longer process that has cost a lot more money. Another thing is it is private. A mediator has a duty to keep everything private and confidential. Same with like a counselor. So if you go to mediation, everything you said will be everything you said will be private. Whereas if you go to court, everything that happens or is said in court is public and is part of public records. Any court case that has ever happened, you can go to the courthouse and basically just look up the records and see what was said and see what happened and see what came upon what. Mediation is a private consultation. It's a private event like that. There's also win-win. There's an offering an opportunity for both parties to win. A lot of times with a judgment, you will get you're either guilty or you're not guilty, and then this person will either pay this or they won't, or this person will pay this and they won't. Mediation, there is an option that if you are a buyer and a seller, you can possibly work something out where, okay, well clearly you want to back out of this transaction because your lease isn't or your loan isn't going to come through. Well, this person's suing you because you can't back out now, it's too late. Well, this person said this person said this, as opposed to just being like, yes, you can sue them for specific performance, yes, you can sue them for damages, or no, they can get out of the contract. You can possibly have a situation where it's like, okay, well, how about we sign a temporary lease agreement? You pay another $2,000 to lease the house out for another half a month, whatever. And then at that point, you can purchase the property because your loan will have been accepted by them. And in that case, both parties win. You get the house you wanted, the seller gets to sell his house, and the seller gets an extra, few weeks of rent money from you. So in that case, everybody wins. And the parties to a mediation will share the cost equally. That is also a key thing. If all of the mediation costs $2,000, you will split the cost, the buyer and the seller in this situation will split the cost, everybody's paying $1,000. Makes it a lot cheaper than, again, going to litigation, in which case not only is it more expensive, but just whoever has the most money wins most of the time. Because you can just sue and sue and sue and sue and sue and sue, file judgment, and then you'll eventually one party will run out of money, and the party that doesn't have that, has all of the money will just end up winning every time. So this is also a good solution if, let's say, you are buying a house from a company who is selling a house or selling property. If there's a whole LLC that has a property and you're trying to buy that from them, there's a good chance they have more money than you because they're an entire corporation, whereas you are just some lonely guy trying to look for a house. So mediation is a good idea because you'll both split the cost equally. Attorney fees. So paragraph 17 says that the prevailing party in any legal process is entitled to recover attorney fees, and that Texas courts have frequently used this paragraph to ascertain that licensees be reimbursed for their legal fees when prevailing in a lawsuit. What this is basically saying is that if you do something that causes the seller to sue you, even if you did not think you did anything wrong, if you go into a lawsuit and you end up winning, your attorney fees will be reimbursed to you. That is all it is saying, is that for licensees, many licensees will have their attorney fees reimbursed when they prevail in the lawsuit. That's all it's saying. Escrow. Paragraph 18 discusses what happens when a transaction does not close and is terminated. If the parties agree on distribution of the earnest money, they each sign a termination agreement, and the title company releases the earnest money. Again, like I was saying, this is a situation that if I was trying to back out of a contract and I knew that I was kind of out of my option period and I was one breaching contract by backing out, you would immediately try to send over a release of earnest money, and if the other party signs it, you send that to title releases earnest money, transaction's over, everything's done with, you can't, there's no more filing lawsuits, there's no more anything, transaction is over. The title company can only deduct the expenses made on behalf of the party receiving the earnest money. There's not much else to say about that. Basically, if the buyer receives the earnest money, the title company can only deduct expenses made. That the buyer, you cannot. If the seller has made expenses, those expenses don't count as the earnest money before that is given to the buyer. Only the expenses the buyer has made will be taken out by the time it's given to the buyer. If a party wrongfully refuses to release the earnest money, the other party can sue them for damages plus the earnest money, court costs, and attorney's fees. This is the only situation in which you can sue for something plus get the earnest money. This is the only situation that you can sue for damages, let's say, plus you will also receive the earnest money, is if a party wrongfully refuses the release of earnest money. If I am trying to back out of a contract, you are allowed to not accept the release of earnest money, but if something has happened where you are kind of required to at that point, or you have already said that you are going to, and then you try to back out of it then or whatever, you've already signed the paperwork, and now you're trying to wrongfully say, well, that wasn't me or whatever, the other party can sue you for damages plus the earnest money, court costs, and the attorney's fees. So, and then lastly with escrow, either party has the right to make a written demand to the escrow agent for the earnest money. And if only one party makes a written demand, the escrow agent will send a copy of the demand to the other party. And if escrow agent making the demand less the amount of the unpaid expenses on half the party, the contract says the parties release the escrow agent for any adverse claims of these procedures as well. That's a really long paragraph to basically say that if I send Wyatt a release of earnest money, because I'm the buyer, he's the seller, I'm trying to terminate my contract, I send him a release of earnest money, he can accept it, we move forward. If I don't send it to him and I just send it straight to title to the escrow agent will receive it and see that I'm the only one that signed it, the seller has not signed it, so they will send that release of earnest money to the seller to have him sign. And then if I'm releasing the money to Wyatt, title will receive the earnest money demand, basically. They'll receive that, take out the expenses Wyatt has costs, send that over to Wyatt, and see if he will accept it at that point. So either way it's going to get to them. It's a lot easier just to send it straight to the seller's agent. Also, that's a good point. As a buyer's agent, you are never to contact the seller at any point during a transaction. After a transaction, it's okay. That's why we were talking about those notices. As soon as the transaction's done, if you have information, you can mark it to them. But during a transaction, you should never be talking to the seller. As a seller's agent, you should never be talking to a buyer. Also, I've had this happen. As a buyer's agent, you should advise your buyers to never contact the seller's agent. I've had that happen where I was in the middle of a transaction, we were kind of going through some stuff, and then I got a call from the seller's agent because we were buying a property, and she was like, "What's happening?" And I was like, "What are you talking about?" She goes, "I received 5 phone calls from your buyer demanding of this, and this, saying that my client needs to do this, the seller needs to figure this out, I need to do this, I need to do that. We almost lost the deal, and I almost lost my license because that is basically somebody going behind their back to contact another party in the transaction they should not be contacting." Again, the way the communication should go is buyer's agent, seller's agent, seller. It's always in that form. You will never have the buyer contact the seller's agent. You will never contact the seller, like anything like that. It will always go from your client to you, to the other agent, to their client. Yeah, I've had that happen before, and it's very, very annoying. And I had to literally sit down with my clients and be like, "You cannot do this. That is against the law to do that. You cannot do that. They cannot be talking to you. They are breaking the law by even answering your phone call. Like they are breaking their contract by answering your phone call. They can lose their license because of that, and I can lose my license because if it comes back that I advised you, or you think that it was okay and I didn't advise you to not do that, it comes back on me as well, and I can lose my license." So make sure that people know that. What I have had happen before, which is kind of a fun workaround, if let's say McKenna is my assistant, and I have told the seller's agent, who is Aiden, that McKenna is my assistant. I'm the buyer's agent. Wyatt is the buyer. Wyatt's the buyer. McKenna is my assistant as the buyer's agent, and Aiden's the seller. I have had situations where Aiden will send his clients the release of earnest money, and then he will send instead of sending it to me, because I will see what's happening and go, oh, we're not accepting that earnest money. I'm going to talk to Wyatt and make sure that we don't accept that and go, we're going to sue for this, this, and this, or whatever. Instead of sending it to me, he can technically send it to McKenna, since she is technically, because I've advised her that she is my assistant, send it to her, and if she doesn't pay attention and like know what's happening, she could send it to Wyatt, have Wyatt sign it, send it back to her, and transfer it that way. That is still allowed because he did not talk to my client in that case. He just talked to my assistant, which since she is my assistant, he is allowed to communicate with her. He cannot, however, just contact anybody at my brokerage and say, hey, can you send this over to Travis's client? That does not work. But as my assistant, he can send it over to her. Now, you do have to, it can come back that you didn't notify the buyer's agent, which would be me. But if he just sends it to McKenna and just like BCCs me on an email, I might see it and go, oh, he's emailing McKenna, no big deal, I'll let her handle that. At that point, I technically was notified because I did get the email, but I saw it was to her, so I didn't open it, I didn't really care, I just kind of let it go. She sends it to Wyatt, Wyatt gets it signed, sends it back to her. Next thing you know, we're out of a deal, we also don't have our earnest money, and I have no idea what's going on. Or like, I guess my client has his earnest money, but I have no idea what's going on. I get a call from Wyatt saying, hey man, that sucked that they backed out, but I'm glad I got my earnest money back. And I go, wait, what happened? And then I have to kind of figure out like, oh man, we could have made them buy the house. We could have sued for damages. They cost us so much more money because they've been running around doing nonsense or whatever. So make sure if you're doing things above the board and you're doing things correctly. Don't contact the seller if you are the buyer's agent. However, you can contact assistants if they have been told you are, or if you have been advised that they are assistants in that situation. Representation. So paragraph 19 says that all representations, covenants, and warranties survive closing, and that seller has the right to continue to show the property, receive, negotiate, and accept backup offers. So what this second bullet is saying is that even throughout the contract, it is not the buyer's property yet, nor do they have claim to the property. They do have, what is that called? Equitable title? Yeah, they do have equitable title, so they can go to the property and do inspections and stuff like that, but it is not their house yet. They do not have the deed to the house. And so the seller still has the right to continue to show the property to other potential clients, receive and negotiate and accept backup offers. So even though you are under contract, you cannot accept an offer, you can accept a backup offer and you can negotiate backup offers. If I am under contract, if Wyatt is buying my house, I am under contract with Wyatt, and Shelton sends me a backup offer and says this is a backup offer, I can negotiate with her and then accept that offer as a backup offer. However, I cannot say, I like her offer better, so I'm going to take that one. Sorry, Wyatt. That is you breaching contract and backing out of the contract. So that is what that is for. Notices. Notices are effective when mailed to or delivered to the address, email address, or fax number listed in paragraph 21. Now again, this is where we put, if y'all remember yesterday, this is where we put, instead of, if I was selling a house, or buying a house, sorry, if I'm the buyer, we do not put my information, McKenna put her information and the office's information. That is because all notices will be given to her, and will then be given to me through her. That's what care of means. Care of means through. So basically, by putting Travis Stahl care of McKenna, you are sending me notices through McKenna. So you're sending them to McKenna's office, or you're calling McKenna about stuff. But that is a legal notice that is given to me because she will notify me of those things. Licensees need to ask the parties what information they want put in this paragraph. Again, you cannot just throw willy-nilly. You can't just put stuff in here. You have to ask them what they want. You might have clients that demand that you put their information. You have to put their information. You cannot tell them no. You can negotiate and you can ask them what they want and you can explain your reasoning. I did have a client once that I started filling out an offer and said, how does this look to you? And they said, what's that stuff in 21? And I said, oh, that's the office phone number, the office email, and the office fax number. And he said, why do you just put my stuff in there? And I had to explain to him, well, this is why, is because one, I don't want them contacting you. And also I don't want anything coming back on you. So if something happens after the deal, I don't want them being able to call you. I want them to have to call me to ask for you. I had transaction with the client that he sold his house. His house is a pool. When he sold the house, about 2 weeks later, I got a call from the seller's agent, or the buyer's agent, sorry. I got a call from the buyer's agent notifying me that the buyers noticed that the pool had flooded and was flooding into the neighbor's property, and they wanted me to go down and fix it. It is no longer it's not my house. It's not my client's house. The transaction's over. It's your house. However, they contacted me because they thought they were contacting my client, because that's what they looked up in paragraph 21. They didn't look at the name. They just looked up email address and sent it. On that deal, I put my work email. So they sent me a notice saying, hello, my client's name. We would like to inform you this and this and this has happened. Can you go over and pay to have that fixed? I received that email and just laughed and just deleted it because it's no longer my house. It's no longer the seller's house. They cannot demand us to go fix anything. They have accepted the property as is. We have already gone through inspections, gone through closing, gone through funding. The possession has changed hands. It is now the buyer's property. They have the deed to the house. That would be like if just right now something happened at my house, so I just called Aiden randomly and said, hey, we noticed this happened. Can you go fix it? Why would he do that? There's no reason for him to do that.
What's his ties?
Yeah, exactly. What's his ties doing? Same thing with my clients. At that point, they have no ties to that property.
Mm-hmm.
It's not something my clients left that made the house over, like the pool over, like flood over. It's been 3 weeks. They didn't leave the pump on and plug all the drains and do a bunch of stuff to make it where it overflowed. It rained a lot and it overflowed at one point. That's not my client's fault. They didn't do anything to that property. Agreement to the parties. So all addenda or attachments that are part of the original contract are listed in paragraph 22. The following forms are never listed in paragraph 22. They are notices, not addenda. So the seller's disclosure notice, the IABS, or the information about brokerage services, and the TAR, notification of intermediary relationship form. Those are not addendas. Those are just notices. Information about brokerage services, that is something you will give out at a listing agreement or at a buyer's representation agreement. That is not something you will do on a contract. So if, let's say Shelton is my client, I will give her a IABS, an information about brokerage services, a CPN, a consumer protection notice, and I will have her fill out a seller's disclosure all before I list the property. That'll all happen before I even list the property. She will have to get all that stuff, she will have to be notified of all that stuff. Basically, an IABS just is a form that shows what I will do as a agent for her. So as an agent, as a seller's agent, these are my jobs. As a buyer's agent, these are my jobs. And then also, here is my brokerage name. Here is Justin Noble's, his phone number, the broker himself. Here is, if I have a team, so under a brokerage, you can have a team. Let's say at Noble's Realty Group, we have a team called Travis Realty Group or whatever. I can have a team that has 10 people in it or whatever. I would, if Wyatt was under my team, he would put brokerage, Justin's name, my name, my team name, like the team name he's in, and then him and his license number. And the reason you do that is so that if anything happens, they know they have been notified basically who you belong to. If you do a deal and it goes south, they know that, well, he was licensed because he did, like, they can look you up and find out that you are part of Noble's Realty Group or whatever. But also they know that basically gives them a form notifying them that you are a licensed agent and you're not just some guy trying to hoodwink them, basically. A CPN, which is also it's not an addenda, it's just a consumer protection notice that basically will tell a client that I am, or basically if I do anything wrong in the transaction, here's where you can go to complain about me, basically. You can go to Truck's website and file a complaint against me. It kind of has all the information of how to do that. Again, just giving your client, you're required to give it to them. It's just a form that shows that, like, this is where you can go. You're notifying them of how to file a complaint against you. That's something legally you have to do. Termination option. We talked about this the other day. It is now in paragraph 5, so not paragraph 23. In paragraph 5, the buyer can purchase an option to terminate the contract within a specific number of days. The intent of this paragraph is to give the buyer time to do their due diligence, inspections, bids for insurance, Checking deed restrictions should all be done during this period to ascertain there is nothing about the home that will not be satisfactory to the buyer. Again, like I said, a showing is a showing is for your clients to see what they like about what they can see, and a inspection, checking deed restrictions, bid for insurance, the option period is for your clients to check that they like what they can't see. So again, showing to check what they can see, and an option period is to check what they can't see. To check for foundation issues, for this issues, for if their insurance, if a flood, if suddenly they have to have a giant flood insurance because you never realized it was in a 50-year floodplain, that's where you would get that's where the bid for insurance would come through. Checking deed restrictions. Oh, I wanted to put mobile homes on here, didn't realize the deed restriction said no mobile homes allowed. Stuff like that. So that should all be done during this period to ascertain that your client will be satisfactory with everything given to them. It is very important the option money be delivered to the seller. This whole slide is wrong. I want to tell you all that now. So if y'all are looking through this online, or if y'all have the slides printed out, you can basically cross this entire slide off because this is all different now that the new contracts have come out. This is very, very important for the option money to be delivered to the seller or seller's agent by 5 p.m. within 3 business days. Stated in paragraph 23, which is incorrect. It is now given to the title company along with earnest money. So it is now given to title company within 3 business days with earnest money. Now, where is it? Yeah, second sentence there. Option money should never be delivered to a third party like an escrow agent. I was watching the old lecture Justin gave on this section, and he literally went, never, 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 and he said it for 5 minutes. Should be given to an escrow agent. Now that the contracts have changed, that's the only person option money goes to anymore is an escrow agent. So that, again, the slide is completely wrong. You will only give money to a title company with or the escrow agent, if that is an attorney or whatever, same thing. But if you owe $2,500 in earnest money and $100 in option money, you will have your sellers wire over the title company $2,600 to cover both of them. So that is also very important there. All days in the contract or calendar days, that is actually very key too. I know I said business days a second ago. All days in this contract are calendar days. However, what this was supposed to mean with option money is that if it was due on a Saturday, you had to give it to them by Saturday. That is not the case anymore because now it's all business days because that is all included. It all goes to the title company and they will not be open on a Friday, or Saturday, Sunday, or a legal holiday. So within 3 days, if it is a Thursday, that'd be Friday, Saturday, Sunday, you have to give it to them by Monday when the title company closes, which is usually 5 p.m. So that is when everything is due. Option money is never refundable. However, it can be credited to the buyer at closing. That is also wrong. It is not, it can be, if you check the box, it is now just always credited to the buyer at closing. So if you owe $200 for closing, or $200 for option period, and you're doing a $300,000 transaction, you technically will owe them $299,800 at closing, because that goes towards closing, along with earnest money. Earnest money also is credited to closing. There used to be a box where you can select if it would or would not be credited at closing. It now states in the contract that it just always will be credited to closing. Consult an attorney. If the parties of the contract have legal questions or concerns, they must be advised to consult an attorney before signing the contract. That is also very key. As an agent, you are required to tell your clients that if they have any questions, they need to contact an attorney. You do not want to be caught, and we talked about the other day, with that that TREC rule. You do not want to be caught in a situation of, well, they never advised me to get an attorney, or that seems like you're trying to avoid them getting an attorney. That is illegal. You have to advise them if they want an attorney to go seek one out. Having an attorney is optional for the parties, but paragraph 23, no longer 24, is now 23. Paragraph 23 gives a place to list their attorney's information if they have one. You do not have to fill that out. That is, I would say 90% of the time, maybe 90, maybe 70% of the time, that is blank. For both the buyer and the seller, it's blank. That does not mean, however, they cannot, if you sign the contract and you didn't fill it out, you can't talk to an attorney. You still can, you just don't have to list their information if you don't want to. Signatures and effective date. All the parties should sign the contract at the bottom of page 9, not page 8, page 9 of the contract. Right, yeah, okay. This completes the agreement of the parties. The licensee who obtains the final signature or the final initial is the one responsible for completing the executed date or the effective date above the party signatures. Again, that is that bold black box that just says executed the blank day of blank 2021, which is the effective date. And under that, it has where your parties would sign. That is the spot where they will sign that they are agreeing to the contract. On every page, you will initial at the bottom of every page saying that you've you've read and you've been notified of this page. This is the box that says that you are signing to agree to the contract. 4 things must happen to have an effective date. So the offer must be in writing. That is, again, the statute of frauds. I know we've talked about that. We've talked about it a few times. That's because it is very important. You will be asked about that on the test. The statute of frauds says that everything must be in writing for real estate. So the offer must be in writing. The offer has been signed by all parties and all changes initialed. Again, statute of frauds, it has to be written and signed by the parties. And all the changes will be initialed. Again, if you have, let's say you're in negotiations and they don't like the closing date, or they don't like the sales price, or they don't like that you want $15,000 in concessions, because that's ridiculous. If I send that over that I want $30,000 in concessions and I send it to Abe, he will most likely just cross it out and initial next to it and leave it, put a 0 or leave it blank, saying he's not going to pay me any concessions. And when I receive that back, if I agree to those terms, I have to initial next to his initial, saying that we both have agreed to this change. The parties have complete agreement on all portions of the contract. Nothing is still being debated or negotiated. So again, in order for you to have an effective date, everything has to be set. You cannot still be talking about, well, what about the price, or what about this? Everything has to be agreed upon. And also the fact that you have written, signed agreement now has been communicated to the other party or the other party's agent by some means. Now you have an effective date. Stop now and fill it out. So if I am buying Abe's property, or I'm the agent for the person buying Abe's property, and I draft up a contract, I think we're good, I send it over to Aiden. Aiden cannot just send it the title and say, we all did it, high five. He has to then notify me that he has accepted the contract. Then he can fill out the closing or the effective date, and then he can send it to title. But only when I have been notified, or my client has been notified that there's been a full agreement between both parties. Page 9 of the contract, that is no longer page 9. Like I said, page 9 just has the effective date and the signatures. There is no longer, this is strictly for information, nothing here is an agreement. That page doesn't exist anymore, so don't worry about it. And then there is the amendments, so check amendment on page 77 supplement, don't worry about that. Once a contract has been finalized and has an effective date, the original document cannot be changed. Any changes after that date must be done with an amendment. Once you have accepted the contract, you can no longer touch the contract. That's how I like to put it. Once you have put an effective date and since title, you can no longer cross something out an initial next to it. There is no more changes that can be done with that contract. That contract is done. Title has it. They will not change it. Title has it in their records, and it is just theirs. If you want to change something, you will have to change. You will have to use an amendment, which again is that page that has the check boxes plus all the things that could be changed. You have to use an amendment, change it on that. Put checkbox, we change the closing date to April 31st or whatever, April 30th, and then sign it, send it from there. There's no 31st. And send it from there. Okay, that is it for the slides, I believe. Yes, that is it for the slides. What we are going to do for the last kind of half hour, 45 minutes of class is we're going to pull up the contract itself, and we're going to go through from top to bottom and fully fill out the contract. Now, like I said, if y'all can, I would advise print out your own and follow along, or I know we're already in class, it's kind of hard to now. Just pay attention, because like I said, this is what we're going to be doing on day 10 as well. We're going to go through and next Friday, we're going to go through and fully complete a contract from that. So, all right. Oh yeah, we'll log into mine real quick, and then we should keep going. To be fair, I might just sit here.
Yes, that's cool.
wasn't filtered, so I'll okay. Okay, so we're gonna use the form that we've kind of been like, we went through a little bit yesterday and filled some stuff out. We're just gonna kind of complete this document real quick. So in this situation, Aiden is the seller, and me and my wife Elizabeth are buying Aiden's property. We went through this yesterday and kind of filled out some of these blanks. And again, yesterday for the property, we found this house, 701 Cherry Street, that's just in College Station. We just found that house. And we filled out the information on that. Here, I'll show you again in case y'all forgot, or in case y'all weren't paying attention yesterday. So to search for that, just go to the Brazos CAD, 701 Cherry. I hit search, and just this property showed up. Click on it, and you get all the information, all the public information about the property. So you have the legal description here, along with the property ID, the geographic ID, the agent, I guess, for the property, the address, stuff like that. Who owned the owner, the owner's name, which is just this company in this case, and where the mailing address for the owner is. Now, you also get stuff like how much acreage the property has and stuff like that, how big the square footage of the actual house is, so it's 840 square feet as of right now. So you'll get all that stuff through here as well. And you also get a map of where the property is. So we went through there, we found this information here, block 11, lot 26 of Oak Terrace CS. Again, whatever is not the block and lot number, that is what the subdivision is technically called. Even if it's extremely long and annoying and just letters and numbers, that is what the subdivision is technically called. That is what goes in this blank here. I know I showed you on that property in Waller that was just like 3 lines long or whatever. Basically, you would put lot, block, and then everything else would go in that blank. And again, when we looked at that property in Waller, there was no specific lot and block because it was like split between a couple, and it had a 3/4 of a foot of this other one and whatever. In that situation, you would just put NA, and then everything would go in this box here. If it doesn't fit there, you would put refer to paragraph 11 dash special provisions, and everything would go in paragraph 11. So yeah, so you put lot, block, subdivision name, city, county, and then the address. So 701 Cherry Street. You don't have to put, you don't have to put 701 Cherry Street, College Station, Texas, because that's what this says right here. It says the city and county is going to be the same, and it says even it's county of Brazos, Texas. So it has Texas in here already because this is a TREC form. And then the zip code right here. What's good about zip forms, like I don't know if you noticed the other day when we were looking this up, if you find the house or if you start typing in the property, it will, I don't know if it will convert. Yeah, there you go. It'll pull up everything that looks like it. So I went like this. It pulls up all of these. You can't really scroll down, but I can do that and find that property, and that'll autofill the zip code to those extra digits as well, not just the first 5. So yes, you have property, the land, you have all the improvements here. So this is all the stuff that will be conveyed at closing. These are all part of the real property of the property you're purchasing. So this is not just the land, but this is also the house, the garage, and all the fixtures and everything like that. And then you also have accessories. Now accessories would be stuff like window air conditioning units, stove, fireplace screens, curtains, rods. Like curtains and rods, for example, that's stuff that you would not consider that like an improvement or a real property of the house. That is something that is kind of more of a personal property thing. But if they're attached to the building, they convey. This is what this is saying, is that anything permanently installed conveys. And again, if let's say we're filling this out like I'm sending this over as an offer to Aiden, so I wouldn't know this stuff right now. But if when Aiden receives this, he wants to keep the curtains, he can put, you want to be specific, so he can put something like this, saying that he wants to keep the living room, he will take the living room curtains with him when he leaves the property. So if he loves curtains or whatever. They were $5,000 curtains. So that's why he wants to take them. Yeah, because he's an expensive boy. So that would be a situation for that. 3 is the sales price. I know we talked about this yesterday. So let's say the house, Aiden is offering $275,000 or $300,000 for this house. Well, I want to offer $250,000. So I take what I want to offer. Let's say I'm doing $20,000 down payment and the rest of it in closing or in financing. This is how I break that down. 20,000 or 20% of 250,000 is 50,000. The rest of it is third-party financing. I know we talked about all of these 3 the day before yesterday, but this is in this situation. I guess was it yesterday? But either way, this is what these are what I want to choose in this situation. I want to choose third-party financing for this. Here are leases. This is a new paragraph. This is one of the ones I was going to say that I was going to have Justin come talk to y'all about, just to kind of help explain things a little bit better. But as a quick run through, these are leases that include the residential leases. So this first one here, A, residential lease, the property is subject to 1 or more residential lease. You would click this if you were doing a seller's temporary lease or a buyer's temporary lease agreement. That is what this box would be for. Now these other 2, fixture leases and natural resource leases, this would be something in the sense of, let's say you have a water softener on the property, but it is not yours, you are leasing out that water softener. You would have to, there's an addendum for fixture leases, and you would have to attach that to the property, or attach it to the contract, sorry. And then same thing with natural resource. If you are not the one getting the natural resource, but you have a natural resource lease, means the oil and gas, mineral, water, wind, other natural resource lease affecting the property to which seller is a party. So you are a party of a natural resource lease. You would have to either deliver a copy of the natural resource lease, or if they have not, you would check and then put how many days they have to give it to you, basically. 5 is the earnest money, and again, we kind of filled this out yesterday, but this is going to be the delivery of earnest money and the option. 5 is the earnest money and the option fee. So within 3 days of the effective date, again, that is 3 days. That is 3 business days. So if it is on a Wednesday, that 3rd day will be on a Saturday. You have till Monday when it closes. If that Monday is a legal holiday, you have till Tuesday when it closes to get that stuff turned in. So 3 business days. Within 3 days of the effective date, buyer must deliver to University Title, that's the only picked here in town, as an escrow agent at 1021 University Drive East. That is the address for University Title Company. And again, we just chose University Title because it's someplace, it's close to us, so I just chose it. You will, and again, a good point about that, now that I think about it. So I just chose University Title because it's close to us, and that house is in College Station, so it's close to them. You have to choose a title company that is a reasonable, that is within reach of the house itself. Now with this house, University Title might be the closest title company. I can still choose any land title because they are in the same town, so it's the same. They're not far away. What I could not do in this blank is put like Stewart Title Hempstead. I cannot put that. I cannot put Burleson Title Company in Caldwell. That is unreasonable to think that we have to drive all the way out there to basically do title. That also saves people from getting referral fees and just going, well, I know this guy who does really, or I know this guy who will pay me, but he's in Galveston, so I'm going to send everybody to the Galveston Title Company or whatever it's called. You can't do that because if the house is here in College Station, it has to be here. It also has to be within the same county. So I can't send them to Burleson or to Hempstead because those are outside of the county. When the title company receives this, in order to do their title searches, they will look within the county. That is another thing that if you are selling a property in Hempstead or in Waller County, they will do a search through Waller County. You cannot choose University Title Company here in town because they will do a search in Brazos County and not find anything, and then be like, we can't do anything because we don't have any information on the property. So that is why you have to choose something that's in the same county, preferably as close to the property as you can, just to make everything easier. So yeah, so he's gonna basically, as a buyer, I'm willing to pay $2,500 in earnest money and $100 as an option fee. The earnest money and option fee shall be payable to the escrow agent and may be paid separately or combined in a single payment. Now, again, I know the slides say that you should never pay earnest or option money to an escrow agent. That is the only way we do earnest money or option money now. Sorry, it's getting confusing to say both of them. That is the only way we do option money now. which actually makes it a lot easier, even though some old timers like Justin think it's very annoying. I know he's been complaining about the change in the contracts and everything, but personally, I think it's a lot easier now. It saves me a lot of hassle, as opposed to having to run a check or run a money order from my buyers to the seller, wherever they may be. I can just have my buyers wire the money to title, and everything's good. And the buyer shall deliver additional earnest money of blank to escrow agent within blank days of the effective date. You will see this again most of the time if you have a really, really long option period. If you chose 20 days for option, you will mostly have to use this. You will use this in a case where you will pay $100 on day 1 and you will pay $150 on day 10 to have the other 10 days if you're doing a 20-day option or whatever. You will see that a lot if you have a long option period. That's kind of the only reason you will see both earnest monies, is just to make sure that when you, or I guess it would be 150, a little bit more, but because it's earnest money. But basically, that just to clarify that even after we've done our first 15 days of option, we're still very, very serious on this property. We'll pay you a little bit more money to show our serious intent. That is what that would come. This paragraph, or this section 3 here, is actually pretty key too. I know, at least for us agents, the money that the agent receives, or the escrow agent receives, will first be applied to the option fee, and then to the earnest money, and then to additional earnest money. So if you have $2,500, like in this sense, $2,500 for earnest and $100 for option, and your client only wires them $2,500, they will put $100 to option, and then they will only get $2,400 for earnest, and you will be short earnest money. And that's where you will find these: you failure to deliver earnest money, buyer fails to deliver earnest money within the time required, the seller may terminate this contract or exercise seller's remedies under paragraph 15, or both, by providing notice to buyer. This is very key. If you happen to miss that, if your client doesn't send a full of both, then they only send enough for earnest, they will not cover earnest. They will cover option first and then earnest. You will then be short on earnest money, and then your seller may be able to terminate the contract at any point and can sue you for specific performance and make you buy the property or sue you for damages. It sucks. So if your client is going to just send them one payment, make sure it's enough. If you have a client that just wants to send them a $2,600 wire once, make sure they're sending them $2,600, because that's what this contract says the total needs to be. Don't have them just read one price amount. Don't have them just go $2,500, got it, and then wire them the money. That will not cover everything. They'll actually be short on the $2,500, not so much they paid $2,500 and then missed the $100 for the option. And then here in B, termination option, this is where you select the number of days. So we chose $100 right here for 10 days of option. Again, this is all negotiable. I can put 110, and when I send this over, the seller who is Aiden can come back and say, how about 200 for 7? That is all possible. He can negotiate that. The title policy and survey, the seller shall furnish to buyer at seller's expense. That is normal. That is the seller's expense. An owner policy of title issued by, and then the title company. This is University Title. It should be the same company you use here. So University Title Company. Again, we talked about this yesterday. And then here, this on 688, these are where the shortages of area come through. And again, we chose to do shortages in area at the expense of the seller, because again, it is usually the buyer that pays for this. But if I am representing the buyer, I want this to be as good for the buyer as possible. Any expense, I want the seller to pay for, because that saves my buyer from having to pay that expense. So your duty is to the buyer, put everything as the seller, make the seller pay for it. If that all works out, cool, you save your buyer some money. That's what your job is. So that is what that is for. The title commitment, again, within 20 days, they have to receive a copy of this contract. The seller shall furnish to buyer a commitment of title, or for title insurance. The survey. In this situation, I'm assuming they have a survey. I don't know if they do or not, but I'm assuming they do. So within 5 days after the effective date of the contract, the seller shall furnish to buyer and title company his existing survey. This is what I want. This is normal that you click this box and hit 5. That is normal. And again, like we talked about yesterday, with this, this right here, this is usually the buyer's expense because again, if your lender does not accept it, if I'm buying a property and my lender does not accept the survey, that's on me, not on the seller. That's not his fault. That's me for having a lender that's not going to accept it. So it's usually me that'll pay for it. But again, as a buyer's agent, I want the seller to pay for it because I want to not have my client pay for anything. Objections. So here, buyer may object in writing to any defects. This is where you put in, like I always put in residential or rental use. This usually says 10 days. I'm going to put 20 because I want to give my buyer more time to back out if they want to. So residential rental use, that is, I guess either use or usage, doesn't really matter. That's what we always put in this blank. Either that or I sometimes will put recreational. Like I said yesterday, if it's land, I will put recreational just in case they buy property solely to hunt or fish on. That is not a residential or rental use, but I just want to cover them in case they want to split it off and then just have that property to hunt on. Title policy. So the broker advises buyer to have an abstract of title covering the property examined by an attorney of buyer selection. Buyer should be furnished with obtained title policy. Here you go, 2, member in a property owners association or an HOA. This is where you would select if you think the property is an HOA or not. If you look on the CAD, sometimes it's hard to figure out if it's in an HOA or not. You don't really know. But you will see on the MLS, there's a spot for HOA or not. If there is, on the MLS, it'll say HOA, yes, HOA amount, and it'll have either like, $75 a month, or it'll say $500 annually, or $500 a month, or whatever. It'll have the amount and then how often it's paid, whether it's or how much it's billed, if it's a year or per month or whatever. Let's see. These are just all the notices. Property conditions. So this is your access, inspection, and utilities. This is where you have you have equitable title. You can go in at reasonable times to do inspections, and the utilities have to be turned on. So the seller shall permit buyer and buyer's agents to access the property at reasonable times. Again, like I said, reasonable. And the utilities have to be turned on. And like I said yesterday, you don't want a situation where you schedule an inspection, you get there with your buyer, the inspector comes, and all the utilities are shut off. They can't access the water, they can't access the electricity, they can't access the gas. They can't tell you if the property's in good condition or not because they can't access any of that stuff. So they don't know if the utilities even work. Maybe there's a giant leak somewhere, but they don't know because the water's turned on. So they will not be able to tell you. You will have to get another inspection and then get the seller to turn the utilities on and pay for 2 inspections. That's very annoying. You don't want to get stuck in that situation. So make sure if you're selling the property, the utilities are on. And even if you're buying the property, make sure the utilities are turned on before you get an inspection order. The seller's disclosure. So if I have not received a notice, let's say I'm buying the property, there is no notice on the MLS, or I have not received an email with a notice. Buyer has not received a notice within 5 days after the effective date of this contract, the seller shall deliver the notice to the buyer. And then again, no matter when they get it over to me, even if they get it over to me on day 5, I then have another 7 days after I receive the notice that I can back out for any reason. So if you are a seller, make sure you have this before this contract is signed. So if I receive this contract, and if I receive a contract and it says this, I will have my seller fill out a seller's disclosure before I send it back. And my counter will just be that I cross off this box and I check this one here saying buyer has received the notice. And that way there's no 7 days that they get to back out. They have received a notice by that point. So that is very key too. And then 3 here, seller is not required if it's not required by the Texas Property Code. Again, that would be in a situation where if it's just land, a lot of land does not require seller's disclosure because there's nothing to disclose because there's no house or there's no improvements on the property. There is just the land itself. The seller's disclosure of lead-based paint and lead-based paint hazards. So if a dwelling has been constructed prior to 1978, it requires a lead-based paint addendum and notice. That is, you will be asked about that on the test. I cannot talk about that enough. 1978, prior to 1978, they will ask that question. Everybody knows that they ask that question. They will ask that question on your test. Acceptance of property, that is what D is about. That is where you would select as is, or you would select buyer accept property as is, provided seller at the seller's expense fixes stuff. Again, I have never done a contract where you select box 2. because again, that just shows the seller that you want them to do a bunch of stuff. They will, if they see that, they will often just not even accept that offer. So it's best just to ask for it as is. If you see something wrong with the property during inspection, you can ask about that during your inspection, in your option period after your inspection. You can ask them to fix stuff like that. The lender required repairs and treatments. Again, this is why you don't, if you are a buyer, you don't send your inspection report to your lender. Your lender will receive it and then require that everything is fixed before they give you any money. If the seller refuses to fix everything, the lender will not fund you the loan and you will have to back out of the contract. That is why it's key. Just don't send it to them. I know that seems really weird to say, but it's best that you don't send it to them, because then you don't have to worry about them. Even if it's something really small, like if there's something in, there's a hole in a wall that you want patched up. The lender will require that it's patched up before you buy the property. However, that's not a deal breaker for you. You'd like for them to do it too, but if they don't, you can pay $10 to buy some like 90-minute bond and just spackle over it. You're good to go. Like it's not a huge deal. So it's just don't send it to them. It's cannot harp on that enough. This F is just saying you have to complete the repairs and treatments. G is those environmentals such as endangered species or habitat or something like that. Residential service contract, again, that is the home warranty, like I said yesterday. It is generally $600, so that is what we're going to ask for in this situation, is $600. I'm a buyer, I want them to pay me $600 to give me a home warranty for a year so I can fix stuff that goes on in the house. And again, the purchase is optional, but as a buyer, or a buyer's agent, I want my buyer to receive that. Brokers and sales agent. If you have a disclosure to disclose, you would put here, you know, if let's say in this situation, I'm sending this to Aiden, and I know, let's see, I know that Aiden is a licensed agent, because that's what it says on the MLS sheet. Is it says that the seller is the owner, or the owner is selling the property, and he is a licensed agent himself. You would put on here that the seller is a licensed agent. If I was buying the property for my mom, I would have to put on here that the buyer's agent is the son of the buyer, something like that. Broker's fees, again, all obligations to the parties and payout of broker's fees are contained in a separate agreement, not on this contract. That is all in a separate agreement. Closing. So here we finally get to the new stuff. So for closing, this is where you select on or before what day you would like to close, or within 7 days after all objections are made under paragraph 60. This is, for example, if those objections, you find out that I wanted 20 days, for example, for those objections. Even if I put a 15-day close, they send me objections. I then have the full 20 days to back up, or to close the contract, not just until the contract closing date is there. But for this, let's just say 30 days. So we're going to go 23rd of May. That's a Sunday, so I'm going to select Monday. And again with this, if let's say we did that and it was the 21st, and 30 days from now is the 21st, do not select Friday. You can, it's normal practice to. Just personally, as Travis Stahl, agent, don't select Friday. It annoys everybody. If it is on the 21st, just move it to the 24th. I know what you're thinking is you're gonna get funding the same day anyway. If I did it on the 21st or the 24th, I'm still gonna get funding on Monday, so why does it matter? It annoys people when the day it says is not the day it happens. So I would rather you move it back 3 or 4 days in the contract and have it on a Monday, and then when you go into close on Monday, you get funded on Monday or Tuesday. That is much nicer than you thinking you're going to close on the 21st, and then suddenly have to wait till the 24th to actually get your house. So just personally put it earlier in the week to avoid that conflict. So that is what I would do in that situation. And if either party fails to close the sale by the closing date, the non-defaulting party may exercise the remedies contained in 15. Again, this is paragraph 15 coming up. Like I said, you'll see it a lot in the contract. That's the paragraph that shows that you can sue for damages, sue for specific performance, or collect the earnest money. And in this case, if we select the 24th and my clients go in at 8 a.m. on the 24th to sign, and these sellers do not show up that day, they want to come in on the 25th or 26th, they just don't show up on the 24th, we can then sue them for specific performance and force them to sell the house, or sue them for damages as well. So that is a key thing is if you select a date, you keep it. You are going to close on that date. If you are not, that is when you would sign the amendment that changes the closing date for all the parties. But that has to be signed by both parties and sent to title, so they are notified of that as well. Possession. So here, buyer's possession. Seller shall deliver to buyer possession of the property in its present or required condition, ordinary wear and tear expected, upon closing and funding. Now, ordinary wear and tear expected, that does not mean that a wall is missing or that the house was flooded. That is not ordinary wear and tear. But if you are selling a property that is older and you lived in the house for a while and then they come in and they notice there's some scuff marks on the floor because somebody walked in with their shoes off, that's normal. That's ordinary. That just happens. So, you know, there's some dirt in the entryway because they're digging something up outside to take with them. That's fine. That happens. Like that is ordinary. It just cannot be excessive. And like I said, it is its present or required condition. If you get to possession at this point or closing, and you do your final walkthrough, and there is a wall missing or the house is flooded, it is the seller's job and the seller's expense to fix that and to get that back to its previous or required condition. And here in this bowl right here, it says consult your insurance agent prior to closing and ownership. That is because of that situation we were talking about. If you are changing closing date, you want to make sure your insurance provider knows that you were changing the closing date. Oh, here is a new paragraph they added in this in April when they changed this. So this is fun. Smart devices. So not only are you getting possession of the home, you are getting possession of the smart devices of the property. Now, what that means is that it's not saying that if you have a Ring doorbell that has to stay with the property now forever. What this is saying is that there is anything on the property that is for a specific purpose. So if you have a smart screen on your wall that you use to control, open your doors, turn on your lights, stuff like that, that has to stay with the property because it has a function that's solely for that house. If you have something that turns on, that opens your garage door, it's not reprogrammable, but it's something that, you know, controls your garage door. Even if it's just an app you have on your phone, you are required to give the seller access, whether it's username, password, applications, all that stuff, so the buyer is then able to access all that stuff as well. Not saying you have to give them access to your phone, nor am I saying you have to give them access to like your whole account if it's like, you know, a Nest account or whatever. But if you have something that will allow them to open the garage door wirelessly and you have no other like button to push to open the garage door, you have to give them access in some way to be able to open the garage door. If you have lights in the house that are controlled by your phone, you have to give them the app and you have to transfer ownership of those lights to the buyer. Unless in exclusions up here, where is it? It's way up here. Unless here in exclusions, the seller states that they are taking all the smart devices, like I'm taking all the color changing lights in the living room with me or whatever, the smart lights. You can put that in exclusions as well. But this is just saying that the stuff that is staying with the property, the fixtures that are staying with the property, if they are controlled by a smart device, you have to give the buyer access to those smart devices. Oh, too far. Yeah, here we go. Okay. Special provisions. So this is that paragraph 11 we've talked about a lot. Again, almost every time, 90% of the time, that's what this paragraph is going to look like. It's just going to say NA. There's not a whole lot of special provisions you need to access for all of these. Let's see. You can put something like this. You can do something like this. So this is basically saying that the only thing I require that's separate, that's a business detail, is I want the seller's agent to leave the keys in the lockbox on the door, on the back door. That way, whenever possession is obtained by my buyer, they have a way to access the keys without having to go to the title company or to the, not the title company, to the seller's agent office to get the keys. That's all this is. You are not allowed, again, to put anything that changes the legal rights. I cannot say you can do this or I can sue you for specific performance. That is not what this is saying. You cannot change the legal rights of things. You can only put business details and kind of just extra little things that you just kind of want to get across. But again, what this is doing is that if the seller signs this, they are agreeing to this term and they have to do this or else they breach contract. Settlement and other expenses, again, this is where if I am submitting this offer to Aiden and I really don't like him and I want my money and I think this is messed up and I want it fixed, I can ask for $10,000 because I want my money to fix stuff. Most of the time, this will either be blank or it'll be a few thousand for this and that here and there. But again, in an offer, this is usually not the case. If people want $2,500 to fix something, they will ask for that when the inspection comes through. The inspection will come through and they will say, hey, we noticed this, this, and this is a problem. Can you either fix that or give us the $2,000 it would cost to fix it? That is when that would happen. This is a weird situation where you can just ask for stuff if you want. I want the tax statement's going to go through and I don't like it, so I want you to give me more money. This is just where you'd ask for money in that case if you wanted it. But usually, that is what will be in this one. Just most of the time, it's just $0. So. Here, paragraph 13 is about prorations for the taxes. Like we said before, if you owe half the taxes, you will pay for half the taxes from the previous year, assuming that is correct. If it is incorrect and it is a lot more than that, you can work it out. That's not usually how that works. Casualty loss, again, if anything happens to the property, it is the seller's expense to fix it, and it is the seller's duty to fix it and get it back to its previous condition before closing. Default, if the buyer fails to comply with the contract, this is where it says you may sue for specific performance if you are the seller. But again, this is not always the seller that can do this. The buyer can do this if the seller defaults or does not comply with this contract. That is what this is saying right here. Seller will be default, the buyer may enforce specific performance or whatever. 16 about mediation, we talked about that earlier. 17 is the attorney's fees, basically saying who prevails in the legal proceeding related to this contract is entitled to recover reasonable attorney fees and costs from the proceeding. 18 is about escrow. So the escrow agent is not a party in this contract and does not have a liability for performance or non-performance of any part of this contract. You cannot be the seller and also be the escrow agent. You cannot be a party in this contract and be an escrow agent. 19 is about representation. So again, this contract survive closing if any representation. So if you have any warranties or whatever on the house, they will survive closing. And again, the seller may continue to show the property and receive, negotiate, and accept backup offers. Here we go. Here are the notices. So for example, if Aiden wants to put in here, let's see, he lives at 123 Main Street. That is where he's moving to. He's moving to 123 Main Street, and his phone number, let's say, is that. And Aiden at mymail.com. That is his email address. So Aiden puts in his information here because he doesn't know what he's doing. This would usually be blank if I'm sending it over because I don't know this information. Aiden would fill this out when he sends it back. And he would just, sometimes they fill all of this out, and sometimes they leave it blank. If you are McKenna in this situation, she is my agent for this transaction.
Yes.
I think so. It's like,
She's represented.
Well, I'm making sure that was the right phone number. I couldn't remember. There you go. So in this situation, McKenna is my agent. I am the buyer. Remember, Aiden is the seller. McKenna is my agent. She puts in the office phone number here and the office email address because she doesn't want me getting marketed to. She doesn't want me getting people yelling at me for after the transaction's over, whatever. This is why she would put her information in here. And also, there is no address. She would not put in my address in this form. If they want to know where I'm moving to, they probably know because that's what the contract's for. So, but either way, this is why you would, if you're the seller especially, you would leave this blank. Agreements of the parties. So this contract contains the entire agreement. And cannot be changed except by the written agreement. Addenda, which are part of this contract, are, and then you check below. So, everybody remembers, we are doing a third-party financing for this, so I would check that addendum. I would also want to check this one, concerning right to terminate due to lender's appraisal, which that is basically saying is that as a third party, if I go through contract and then when it comes to funding, the lender does his appraisal and finds out that we're offering $200,000 for this house, but the house is only worth $100,000. Well, that's ridiculous. So I'm not going to give you that $200,000. You don't need the $250,000 for the house. It's not worth that. This gives me the right to terminate due to my lender's appraisal of the property. Can anybody think of another one that we might need to use for this property? I will pull up. I don't know if it actually has it on. Yeah. You think of what I need for this?
For a year ago, when you did the 19.
Correct. Yeah, correct. So since this property is
the 19.
yeah, 1978. That's the best way to remember it. Yeah, since this property was built in 1952, that is before 1978. And because of that, I would also have to do a seller's disclosure of information about lead-based paint or lead-based paint hazards as required by federal law. That is something that people miss this box a lot because they just don't check when the property was built. You go do a showing, somebody says they like the house, you go, cool, I'll write up a contract, and you just write up a contract. You don't actually look back on the CAD to see when the property was built to see if you actually need this disclosure. Also, another thing that we would put in here. Now, I cannot explain this, but we use this in literally every transaction we do, this non-realty items. Again, this is where we would put out that we want the fridge and the washing machine and any and all other personal property left at the property at closing. That is a key situation. Like I said, you don't want to be caught in that catch-22 where your buyer gets a house, they get possession, they get funding. Sweet, let's go move in. They go to move in, and all the seller's stuff is still there. And the seller's like, oh, well, we're going to move. It's going to be a week or two, so we're just going to, we were waiting on the moving companies to get free, and it's like, well, we have nowhere to live now. We have our moving company here. I'm not paying them for a week to hold my, that's not how this works. In that situation, by adding any and all other personal property, you can just have the moving company move all your stuff in, take all your stuff out, and just leave it on the front porch. It's all yours now. The seller can't take it with them. It's your property. So that is why this is a key thing we add in there, just to cover our bases, make sure we don't get caught in any weird situations. But also you would use this if you want the washer, the fridge, anything else that is not in that paragraph B and C that's going to be left with the property. Now, what I can't explain is why we use this in every transaction, and most companies use this in every transaction, and they haven't made it a preset box to click. I have never once used the addendum for authorizing hydrostatic testing. I've never used this addendum before, but it's one of the preset ones. But for some reason, this one isn't. No idea. Can't explain why. That's just how it is. So you just gotta always put that one in. 23, again, if you were to consult an attorney, you would select this box. Most of the time, 75% of the time, it's just left blank by both parties because you don't have to put your stuff in. I know an attorney I could call. I actually know one that works with my dad's best friend that I could call anytime to ask him about some stuff. I'm not going to put his stuff in here because there's no real reason to. I know that if something comes up, I can still just call him. I don't have to put his stuff in here. So that is usually left blank. Here we go. So this is the entire page. This is page 9 of the contract. This is the page that is literally solely just for executing and signing. Now, it used to be that I think before this contract was like this paragraph, like half of this stuff and this attorney stuff was on top of here, and then this box was like here, and there was signatures down here. It was a little bit harder to miss. You still shouldn't have missed it. I did somehow. I'm just trying to make excuses for myself. But if you're sending an offer, you would never fill out this box. This page should basically, the only thing this should have on it when you send it to the seller's agent is the two initial or the signatures by the buyers. So again, McKenna is my agent. She is filling this form out for me and my wife Elizabeth. She would get our signatures on here, and then she would send it to Aiden or to Aiden's agent if he has one. If he is the agent, like we said in the other paragraph, send it to the seller's agent. They would get Aiden to sign it if he agrees to the terms, and they would fill out this date and then send it off to title and let us know. Again, they have to let us know that they accepted the contract. If we send it off and they don't like it because we put $50,000 less than what it's worth, or what his offer price is, or what his asking price is, he would cross that out, initial those changes, and send it back. But he would not sign this blank here. If we're negotiating, you do not sign the contract. You don't want both parties' signatures on it, because that means you agreed to everything that's on the contract. He has not agreed to everything that's on the contract. So he would change it, initial next to the changes, send it back to us, and see what our counter to his counter would be, or if we accept his counter. If we accept his counter, we would just simply initial next to all of his changes that we also agree to them, send it back to him. At that point, he would sign it. He would fill in, his agent would fill in the executed date and send it off. And then here we go with the broker's information. So again, I think I have it all in here. So this would be the broker's information. I guess this would be McKenna. Her name would go in here. So let's say McKenna's name was in there. We have the address of the brokerage here, the phone number, all that sort of stuff. So this is what it would look like if McKenna was filling out a form for me. This is the only spot that would have any of her information on it, except for the notices. If she did her part correctly, her name, then it would have her name there along with the company's phone number and email, or her phone number and email, but never mine, never the buyers or her clients. But this is where you would have your information along with, at this point, I might not know it. If I do know it, like I found it on the MLS or whatever, I can put in whatever Aiden, his agent's company is. I can put in that real estate company. You probably wouldn't know their license number offhand and stuff like that, but this would be something that you would have them fill out when they receive the contract. Another big key thing here, in here, you are going to do this basically every time. If you do not put 3% in here, you, as a buyer's agent, are not entitled to any commission. Do not forget that blank. They love to put it right at the bottom of the second to the last page of the contract. So it's a good chance you'll just miss it. Don't miss it, please. Please remember to put that in there because it's very important. Now, what this does say is that pursuant to a previous separate agreement, such as an MLS offer or compensation or other agreement between brokers, if the brokerages have already had an agreement, they will pay each other this much, that will supersede whatever I throw in this blank. On the MLS, you will sometimes see, let me see if I can actually pull one up real quick. On the MLS, at the bottom of the page, it will say how much they are, basically how much they're getting and how much the other agent's getting. It's usually 3 and 3. Sometimes you will see some, and they will say 4 and 2. And basically what they're saying is the seller's agent's going to get 4% and the buyer's agent's going to get 2%. It's very easy to miss that on here as well. So if I go here, just do a quick search. Let's do that. So just a house that's a 3-2, and I want to do that one. Sure. Usually on here, it'll have, so this is if you're a member of the BCS, the BCS MLS, and you do a deal with these people, you will receive 3% commission. So the seller will get 3% and you will get 3%. If you are not a member of the BCS MLS, you will only get 2%. I have seen this be 1 and this be 0 before. Be wary of that. If you go show that house and they buy that house, you will only get 1% commission, not 3%. Watch out for that. Because especially if you're working with a third party like Opcity, Opcity will take 35% of your commission. Well, they will take 35% out of their 3% they think they're getting. If you only get 1%, you will actually owe them money, as opposed to just paying them part of your commission. You will give them all of your commission and then owe them a little bit extra. So it's very key to watch out for stuff like that. Yeah, and then here is where basically you will send title company, option earnest money, and the contract. When they receive the contract, they will get this, and they will put in their escrow agent, the email address, and stuff like that for the title company. When they receive option and earnest money, they will fill this stuff out. In order for a contract to be complete, in order for a title to grant funds and everything at the end of the contract, this page will have to be filled out. The only thing that might not be is this, because, for example, this contract, we don't have additional earnest money. So that is the whole contract. We got through it basically just in time at 7:29. But I just wanted to run through the whole contract real quick with y'all at the end to help y'all out. And like I said, if y'all want to go back and watch this video, or if you're taking notes on a contract or something like that during the class, this is what y'all will be doing for your last, like for day 10. I will go through this again step by step on day 10, because again, this is very important. I will go through this again. I will have y'all fill out a contract and email it to the capstone email address. And I will go through them, or go through it one more time and kind of explain what's what, who got what, and why it's right and wrong, and everything like that. So that'll be the whole last class, will just be this. But if y'all already did, if y'all are paying attention, I've kind of run through it for you here. What I will do too, to kind of add on to this, is I will, because I am the seller and Aiden is the buyer, or I'm the buyer, sorry, and Aiden is the seller, I will in zip forms here, send this to Aiden. I'll sign it, send it to him, have him change stuff, initial it, send it back. I'll change stuff, initial it, send it back. We'll go through a process like we're negotiating. That way on Monday, I can show y'all what a completely executed contract looks like when it's completely filled out, because it's very messy and it's very annoying. Because you will have contracts where right here, there's a line through 250, it says 300 right here, initial. Then I get it, I initial that out, I put 275 here, and then initial next to that one, and then he has to initial next to it if he agrees, or he'll cross that out and put it somewhere else. And then suddenly you have this cluttered mess where all the margins are filled in with just initial boxes, and it's a mess. But for some reason, what they should do is have us do this, and then when everything's done, have us redraft a contract with all the correct information. That's not allowed. So it's like, so you know, with this messy contract. But I will do that just to show you what it looks like at the end, so y'all can kind of get an idea. But other than that, I will, before we log off, I will say that is all for class today, but I want to tell y'all that make sure y'all are logged in to this course, or if y'all have gotten an email like inviting you to this course, y'all have accepted it. I know apparently we have gone through and there have been multiple people who are not actually in this classroom, like in Google Classroom, have accepted the invite, and I don't have anything from them. We haven't had anything from them for the last class either. It's very key that if you have been invited to this class, that you accept the invite, go through and are filling out all the coursework. We actually have some people who didn't have the test turned in because they're not accepted the class invite, so they're not even in the class yet. So they're here, but they're not doing the work, and they're also not even in the class, the Google Classroom, so they have no grades. All I can stress, I'm not going to point at anybody, but all I can stress is that if you are in the classroom, if you are listening to the lectures and you are doing all that stuff, make sure you find that email from the capstone email inviting you to the classroom and accept it. If you don't have it, I will send a new one out to everybody. Hopefully, we can get that set up this weekend, inviting everybody to the classroom again to have that stuff finished. Other than that, y'all have a good day, and I will see y'all Monday.